Okay, I think we're live. Everyone that's here, welcome to the webinar. My name is Trevor Anderson. I'll be moderating this exceptional panel. We've got a couple great panelists here. The topic of this webinar is combining EB-5 visas with a lens towards the EB-5 program. I think we're all here with a common interest or participation in the EB-5 program, and we have a very interesting topic here about alternatives and strategies that we can employ in partnership with the EB-5 program to help our clients and investors achieve their goals. Before we jump into the panel here, I want to ask our two panelists to introduce themselves real quick. Marjan, would you go ahead?
Absolutely. Hi, good morning, everyone. First off, thanks for joining us this morning. My name is Marjan Kazra. I'm the managing partner at Lawmaks. So Lawmaks is an international law firm. We have offices in New York City. We're headquartered in Stamford, Connecticut. We also have offices in Dubai and Istanbul. I specialize in EB-5 and other investment-based visa categories, and I'm very happy to be here. And we're going to make ourselves available after the talk for questions, and feel free to email any one of us afterwards. We're happy to help.
Thank you, Marjan. Jeff?
Thanks, Trevor, and good morning, everyone. I'm Jeff Goldman. I've been practicing immigration law for 31 years, concentrating in employment-based immigration. My offices are located in Cambridge, Massachusetts, just outside of Boston. We do a tremendous amount of legal work with people applying for EB-5, but mostly what we do is help them with strategic solutions while they're waiting for EB-5 priority dates to become current and to arrive in the U.S. I'm also co-founder of a company called the Build Fellowship, which I will be mentioning later in the presentation, because Build is helping people with some of the strategic pathways to get to the United States.
Great. Thank you, Jeff. And I'm, of course, Trevor Anderson. I'll be moderating the panel. I am the director of EB-5 for HomeFed Corporation. We are a real estate development company, although we've been very active and very successful in the EB-5 program for the last 8 years. So I'm honored to be here and help lead this discussion, although I will readily admit that Marjan and Jeff are the experts here. I'm just going to try and help move the conversation along.
Yeah, the emails were sent out.
I think someone needs to put their mute on, whoever is.
Yeah, there we go. And as Marjan suggested, we will open this up to questions about 20 or 30 minutes in. We welcome your guys' discussions in the chat. You'll be able to enter those questions, and we will respond to as many as we can within the hour. So before we get into the real subject matter, which is this cap exempt H-1B program, Marjan, can you give us a little bit of an intro to the RIA and the visa bulletin?
Absolutely, absolutely. So guys, anyone who's interested in EB-5, and if you've been looking into it for a few years now, which is usually the case, prior to Reform Integrity Act of 2022, the average processing time for any given EB-5 was about 5 years, I would say about 60 months. If you look right now, we're down to about 53.5 months, but the RIA has changed the topography by quite a bit. So what's happening now is that according to Congress, EB-5 has been broken down to different sections. If you are investing into a rural area, there are set-aside visas. So about 20% of the EB-5 visas are set aside if you invest into a rural project which is a regional center project. And if you invest in those types of projects, your investment is going to be considered, your visa is going to be considered current immediately, because you have those visas available to you immediately. Now, in addition to the rural areas, there are some other very good projects that are in TEA zones, and those TEA zone projects, 10% of the visas are allocated to those projects, And so 10% of the visas will be immediately available to people who file into regional centers that are in targeted employment areas. Additionally, there are 2% of visas that are set aside for projects that are in infrastructure regions. And so again, if you invest in one of those projects and assuming that the 2% of visas have not been used for that year, then you're able to take advantage of the EB-5 visa. Now, this is a welcome news, particularly for Chinese and Indian nationals, especially because prior to the RIA, you would have had to wait upwards of 10, 15 years sometimes for a visa to be available. So even if your I-526 petition processed, you would still have had to wait a very long time for that visa to be available. So we're going to be looking at the visa bulletin in a little bit into this program. But basically, the RIA has become a game changer for people who are able to file for their adjustment of status concurrently with their EB-5 filings. Now, Jeff is going to talk a little bit later about what happens if you are falling out of status, and I think his program is an absolute miracle for a lot of people, especially because some of you who may be on H-1Bs, some of you who may be have filed for an H-1B but not won in the lottery. Jeff's program provides for kind of a bridge into it'll provide you with the ability to stay current and preserve your status without falling out of status. So that will open the door to your ability to be able to file for an EB-5 or any other kind of a visa later on. So that said, Trevor, maybe we should look at the slides for the RIA, if you don't mind.
Yes, we're working on
So
trying to
let's
get that up.
take a look at the visa bulletin if we have that available.
Hey, Jeff, if you click the little share button at the bottom of your screen, will that give you an option to click on your PowerPoint?
Trevor, I am looking for what you're talking about, the share button.
Right in the bottom center of the screen, it says share with the green arrow. And you should be able to.
I know what I'm so sorry. I'm not.
That's okay. Why don't I just continue speaking while that's happening?
Okay.
Okay,
Sure.
so essentially, guys, RIA went into effect March of 2022. Actually there were a bunch of lawsuits that prevented it from moving forward. But the first visas that we were able to file, I don't know about you guys, Trevor and Jeff, but the first application that we were able to actually file after like all the dust settled was in September of 2022. And since then, we're seeing approvals rather rapidly, especially if you are in a rural area. And the reason I emphasize rural is because, oh, there we go. So if you could take a look at the visa bulletin there, the fifth category, which is the employment-based visa category 5, which is essentially EB-5, there used to only be just the one row. Now you have the unreserved areas, then you have the set aside rural, which is the 20% we just referred to. And then you have the high unemployment area, 10% reserved, and the 2% for the infrastructure. Prior to RIA, we only saw the unreserved section. And if you look at that, there's still a backlog for Chinese and Indian nationals. So there may be some of you out there who are still waiting. You filed your application prior to RIA. And you are probably still waiting for your visa to become current. So, if that is your case, you may want to consider maybe refiling your application, or, we're happy to look at your other options to see whether maybe you could potentially qualify for an L1 or something like that. And we're going to talk about L1 shortly. But I also wanted to point out the difference between Table A and Table B. So if you're filing from overseas, you will be looking at the numbers from Table A. If you're filing inside United States, you will be looking at Table B. And this is the visa bulletin for September of this year. Each month, guys, it changes. So all you have to do is type in visa bulletin September of 2024, October, so on and so forth. So with that said, this looks pretty good for now. If you see the notation C, C just means it's current. So that means all of the categories are current for the set aside for all nationalities. And this is a godsend, especially for Chinese and Indian nationals. So if you were to go into a project like Trevor's or any other project that is either TEA or rural or infrastructure, you would be able to file concurrently for your adjustment of status. So that's if you are here inside United States on some type of a long-term non-immigrant visa, like an H1, L1, F1. So this is a perfect program for guys like that. And again, if you're falling out of status, that's where Jeff steps in, and he's going to explain his program later, a little bit later in the game. So guys, why don't we look at the other slide, if you don't mind?
Hey, Marjan, real quick. So we see lots of C's on the chart, which is great.
Yes.
What actual processing times are you seeing for both urban and rural?
That's a very good question, Trevor. So for rural, the fastest one that I've had was in 3 months, which is a one-off. I wouldn't tell people, to look for an approval in 3 months. But the average time that we're seeing is between 7 to 10 months. That's for the rural projects. For the targeted employment areas, it's not as bad. I mean, it's not as quick, but it's not horrible either. We're seeing them as quickly as about a year and a half or so into the filing. And to be quite frank, if you're inside United States, I wouldn't be too keen on filing for rural versus TEA. Just go with the project that makes sense to you, especially because you will have the ability to file for adjustment of status from day one. And because of that, waiting for the I-485, which is your adjustment of a status application, takes roughly 19 months now. So it really doesn't matter much if your underlying I-526E it gets approved in 7 months versus like a year and a half, because you're going to have to wait for that green card for about a year and a half anyhow. So I would choose very wisely, and I wouldn't rush into a rural project just because it's rural.
Okay. So we're talking about 6 to 18 months for 526 approval. So investors that are not inside the United States, even though we're current, we're still looking at a waiting period, right? They can't come to the US right away.
Absolutely. So if you're outside of United States, then you would just have to wait for your I-526E to be approved. And after that, you undergo a process called consular processing. And the consular processing depends on which country you're from, but it could take as long as maybe 6 to 12 months for you to get consular process. Some embassies are not as busy, and we're able to push those through faster. But most embassies, I don't know, Jeff, what your experience has been, but roughly 6 to 12 months, I would say, is a decent projection of time for that.
Yes.
Okay. All right. So yeah, so that's as far as that is concerned. Now the EB5, let's see, the next slide talks about EB5 candidates yeah, we could kind of skip that probably. So there are some long-term non-immigrant visas, which we also specialize at Lawmaks. One of them is L1. So if you are you have a company overseas and you want to be able to come to the States faster, possibly, we could utilize what's called an L1 visa. L1, they're done two different ways. The first way, which we handle mostly, is called an L1 new office. And that's where somebody who has, a relatively medium to large size company overseas, if you decide you want to have a subsidiary or a sister company here in the United States, then your company in the US will be owned by your overseas company. And then it's just a matter of filing for your L1 visa, which is going to be a two-step process. The first step involves filing a petition with the United States Citizenship and Immigration Services. So USCIS has a premium processing process for an L1 visa, where you pay $2,805 extra in application fees, but in return, they will approve your petition in 15 days. So that's an excellent way to get in the United States a lot quicker if you wanted to come in here and perhaps go to your regional centers, check out what project you really may want to invest in. L1 will provide you with a quick way to enter United States. So that's the L1 visa. Another category for L1 is just where the company overseas already may have a branch here in the US, and then you would just transfer people from the overseas branch to the United States, and that can be done in two different ways. If you come in on an L1A category, later on, we could look at an EB1C for green card purposes. If you come in as a manager, then you will be an L1B. You'll be a bit more limited, especially if you're in a large company, you don't necessarily have executive duties. That's, for people who may want to look into EB5 later down the line to see whether that would be a way to get a green card. Now, with the E2 visa, this is not for for every country. It's only meant for certain countries. They're called treaty countries. And what a treaty country means is that this is where your own country would have to have a treaty of amity or some sort of a political agreement where the two countries are in good relationship and that they will allow for trade to happen between the two countries. Some examples are Turkey, Israel, European countries. Unfortunately, India and China are not, part of the treaty countries, so we won't be able to use that for Indian and Chinese nationals. So that's my 2 cents on these two visas. If Trevor, you have any questions or?
No, I think that's great. I think we obviously know there's a lot of different visa categories and options, and different investors are going to be better suited for different options. But I think now we're ready to really jump into this H-1B cap exempt program. I'll turn it over to Jeff and let him kind of set the table and kind of explain this exciting opportunity to us.
Thank you, Trevor and Marjan. H-1B is one of the more common ways that foreign professionals come to the United States to work temporarily on a work authorized visa. An H-1B requires a U.S. employer to offer a job that is a specialty occupation. That means the job duties must be so complex that only one with a specialized degree can do the work. And the foreign national, who's going to be the beneficiary of the company's H-1B petition, must possess that specialized degree, or at least the equivalent of a U.S. degree in that field. The problem with H-1B is that they're limited in number. There's only 85,000 every fiscal year, and the government conducts a lottery every March to pick out the 85,000 winners, and everyone else is basically out for that fiscal year. For those inside the US, perhaps in F1 student status, and they're in the portion of their F1 status where they're working, and they're going to run out of F1 work eligibility either after 1 year or 3 years. And many of these people are freaking out because they have lost this annual lottery 3 years in a row. So this is a significant problem to U.S. companies and foreign nationals who want to be in the U.S., that there's only 85,000 H-1Bs every year. But there is an exception to the rule. Congress has declared that there are 4 organizations that can always file an H-1B petition at any time of the year without needing to win the H-1B lottery. These 4 organizations are universities, government research organizations, nonprofit research organizations, and nonprofits that are affiliated with the university. They are exempt from the annual cap of 85,000, and that's why they are called H-1B cap exempt organizations. So nice to know that if you're looking to come to the US and the options that Marjan just mentioned, the L1 or the E2, those are not going to be viable for you. H-1B is perfect for you, but there aren't any available. If you want, you could be looking at employment at any of those 4 kinds of organizations, knowing they can always sponsor an H-1B for you. But what if you don't want to work for one of those 4 organizations? What if you want to come to the US either to work for your own company or some other for-profit company that is not one of those 4 organizations? Or maybe you just want to come to the US and be here while you're waiting for your EB-5 priority date to become current, and then the lengthy processing times that Marjan just mentioned to get to the place where you can finally arrive in the United States with your EB-5 green card. Well, there is a way to work with the cap-exempt H-1B program to legally come to the US. Here's how it would work. Let me back up to these 4 organizations. What if one of those 4 organizations sponsored you for a cap-exempt H-1B without winning the lottery because they can? Let's just say it's a university. And what if the university sponsored you for a part-time H-1B, because H-1Bs can be part-time, and the university applied for you for the part-time H-1B, and maybe 3 weeks later, it's approved. Amazing. Now you could, if you're inside the US, you have officially changed your status to H-1B. And if you're outside the US, you can make an appointment at the US consulate to get an H-1B visa based on this part-time H-1B that's been approved by the university, and you arrive in the US in H-1B status. Well, there's an amazing section of the immigration code that says anybody inside the US in H-1B status can have a second H-1B at the same time. It's called a concurrent H-1B because it's concurrent with your first H-1B, and now you're entitled to a second H-1B at the same time as the first. So if the university brought you here on the cap-exempt H-1B, you are now allowed to have a second company. Maybe it's your own startup. Maybe it's your massive multinational company. Maybe it's your massive company in Asia, and they now could, if there is a US entity that they are associated with, or any US entity, they could file for a full-time H-1B. And now that could be filed immediately without winning the lottery as well. So now you are absolutely legally working part-time for a university, full-time for the company you want to be working with. And this would go on until the date that you finally are able to get the conditional green card through the EB-5 program. All right, what if you don't know a university who's ready to file a part-time H-1B for you? This is exactly why I helped co-found a program called the Build Fellowship. The Build Fellowship is working with many nonprofits who are affiliated with university. Back to the other slide. One of the cap-exempt organizations is a nonprofit affiliated with the university. And there are 4 or 5 of them that are now partnering with the Build Fellowship. The Build Fellowship will work with one of those nonprofits affiliated with the university, and they will hire you. The nonprofit will file a part-time cap-exempt H-1B for you for 5 hours a week, a part-time H-1B, totally legal. And they will get that approved fairly quickly, and you are now in the US. You might need, if you're outside, you'll need the visa to arrive in H-1B status, and now you're employed for 5 hours a week by the Build Fellowship and their nonprofit organizations. They're putting you to work for very interesting work. They're putting you to work 5 hours a week, leading undergraduate students through experiential learning opportunities in the same field in which you have expertise. So if you have expertise in mechanical engineering, you'll lead university students in a project for 5 hours a week, teaching them hands-on, what is it like to do a mechanical engineering project? If you had degrees in computer science, you'll lead them through a very interesting real-life computer science project. And We have hundreds and hundreds of students at all moments clamoring to get into these experiential learning opportunities. So there's no shortage of programs that the Build Fellowship is putting together where you can work for the 5 hours a week. As soon as you are here working in H-1B status for the nonprofit partnering with Build Fellowship, any U.S. company can file a full-time H-1B to be concurrent with the part-time H-1B through the nonprofit. All of this is going extremely well. You don't need the Build Fellowship if you can find your own CAP-exempt organization to do this with. But this is a life-saving solution for those who are in the US and running out of work authorization, or they're outside the US and need to be here working now, and they understand they can get a CAP-exempt H-1B, but they don't know how to get, they don't have a contact with one of these organizations or a job offer from one of these organizations. A reminder, like all H-1Bs, anybody who's going to work with the Build Fellowship must qualify for H-1B. So you have to have a minimum of a bachelor's degree or its equivalent in a specialized field. You must have at least 2 years of experience in that related field. And the third requirement here, I do want to talk about for a minute. It says that you need a legal entity that's able to cover the financial commitment. This is if you're working with the Build Fellowship, because who is it that's paying for the nonprofit affiliated with the university to prepare and file their H-1B petition? Who is it that is paying for the Build Fellowship to get these university students to be receiving your expertise? Who is it that's paying for the government filing fees for your H-1B? It's either your concurrent employer who is going to be filing for the full-time H-1B, or if you don't have a concurrent employer, it's some kind of a legal entity who will cover the financial costs of the entire Build Fellowship program. A quick timeline reminder, and this would be true whether you're working with Build Fellowship or you find your own university or your own nonprofit research organization or government research organization. This is how the timeline for any CAP-exempt H-1B works. It would take 2 to 3 weeks, maybe a month, to discuss the work that you'll be doing in the United States to be sure you qualify for this specialty occupation and you have the right educational background. And then it's going to take about 6 weeks for your lawyer, any lawyer, the nonprofit lawyer, the university lawyer. It's going to take them time to prepare and file and get the CAP-exempt H-1B petition approved. A total of 6 to 8 weeks. And once it's approved, if you're in the United States, your status is automatically changed to H-1B. If you're outside the United States, you need to get a visa and enter the United States in H-1B status. And then very quickly, after you're in H-1B, literally within a week of being in H-1B status, you're going to, if you're working with Build Fellowship, your fellowship will begin. If you're working on your own with a university or any other CAP-exempt organization, you can begin working in your first week here. But it's also that right away, within 1 week of being in this part-time CAP-exempt H-1B status, any U.S. employer can file its full-time concurrent H-1B. And while you're here in the U.S. working on a temporary work visa, whether it's the E2 or L1 that Marjan talked about, or the CAP-exempt H-1B that I've been discussing, you are working on your EB-5 green card, and the processing time is passing. And this is what we're trying to describe to you are ways you can be in the US legally working while you're waiting for the rather lengthy processing times for the final EB-5 immigrant visa if you're outside the US to be approved. Or if you're inside the US and you're running out of work authorization, these are solutions to permit you to work while you're waiting.
Hey,
So,
Jeff, so going back 2 slides, looking at the timing. So if I'm an EB-5 investor outside the country, I'm looking at least 1 year, maybe 2 years before I can actually come to the US, right? Because I need my 526E approved, and then I need to file for a visa, right, with the consulate. So looking at this timing, is it fair to say that I could come to the US in about 3 months?
yes.
Okay.
Yes. And this is true not just for the Build Fellowship Program, but anybody any CAP exempt organization where you can find part-time or full-time employment. They could be processing this and get this approved within 3 months, and you'll be in the US working legally. No need to win the H-1B lottery.
So once they're in the US, then they can file for an adjustment of status as it relates to their EB-5 petition, right?
That's correct. Let me ask you, Marjan, what would happen if somebody has started the EB-5 process from outside the United States and they have filed an immigrant visa petition, and they're waiting and waiting and waiting, but now they arrive in the US in valid H-1B status, and as Trevor said, they might want to switch to adjustment of status. How would that work, Marjan? And you're on mute, Marjan, you're on mute.
Sorry, thank you. So this actually works perfectly in that scenario, especially because H-1B, as you know, is a dual intent visa. So because it's a dual intent visa, the intending immigrant could have either an immigrant intent or a non-immigrant intent. So if they enter, let's say they have filed their I-526, way back when, and now they enter United States on Jeff's fellowship program, then we should be able to file for their adjustment. I don't see a need to wait the 90 days, Jeff, especially because, there's the 90-day rule where if you enter with a non-immigrant visa, they want you to wait 90 days prior to filing for any kind of an immigrant petition, which will be your I-485. In this scenario, I don't see the need to wait the 90 days, especially because they're coming in on an H-1B, which is one of the two dual intent visas. So if you're here on an H-1B or an L-1, I don't see the need to wait, and we could file for your adjustment pretty much immediately.
What will happen to the foreign nationals immigrant visa processing that's taking place
Sure.
abroad?
So we basically what we do, Jeff, in those cases is we would inform U.S. Immigration, especially National Visa Center, that this immigrant is now intending to change status inside or adjust status inside United States. So then that process will essentially become abandoned or moot, and we'll just move forward with the adjustment inside United States. And I haven't had any problems with USCIS questioning why. If it were the other way around, where the immigrant starts adjusting inside United States and then they decide they want to do consular processing, that's where it becomes a little bit more complicated, and we may have to file an I-824 or something like that to switch them over to the embassy. But coming from consular processing, switching over to USCIS adjustment of status is a non-issue.
Thank you.
Of course.
So I think we're ready to take questions. Trevor, are there people who have posted questions?
We do have one question. Let me ask you one more question before we poll the audience. So again, if I'm a EB-5 investor, I've applied to a CAP exempt H-1B. I'm now in the US. I filed for an adjustment of status pertaining to my EB-5 petition. Do I need to continue working under the CAP exempt program, or at what point can I abandon that and just say, I'm waiting for my EB-5 petition now?
Great question. You can abandon the cap exempt H-1B and stop working for the cap exempt employer when you have any other legal reason to be inside the US. So if you have now filed adjustment of status from inside the US because you're going to get the final green card here, that filing permits you to legally remain in the US. Although you cannot work until you receive an employment authorization document, which is taking roughly 3 months. So we do have EB-5 people arriving in the US on cap exempt H-1Bs. They file adjustment of status. They want to continue to be able to work both for the cap exempt organization and concurrently for their private for-profit US company for whom they are working. So they don't withdraw from the cap exempt yet. They wait until they get the employment authorization document, again, coming about 3 months after they file the I-485 for adjustment of status. And then they say, okay, great, I'm done. I don't need to keep working the 5 hours a week for Build Fellowship or any other cap exempt organization. I don't need to keep paying any fees that are associated with that program. And I'll stop because I'm legally here and I'm legally working and on my way to green card.
Right. So it really can be used as a stepping stone. It's not a permanent engagement. This is maybe 6 months to get where you need to be, and then you can move on.
That's exactly right.
All right, we do have a few questions here. Please, anyone that has questions, put them in the chat, and we'll try to get to them all. So this one, well, I'll put it out there, and we'll see who it's best suited for. This says, my H1 is maxed out, and I'm on an H4, an unpaid vacation, waiting for H4 EAD. What are my other options? Do I have L1 and Build Fellowship as an option?
So if I may just answer the L1 question, the L1 will only become a solution if you were working for another company overseas for at least 1 year in the last 3 years, and that company wants to start a branch here in the United States. So L1, for L1 to work, there has to be a relationship between an overseas company and the US entity. So that may not necessarily be a solution. You know, depending on your nationality, we may be able to switch you over to an E2 if your country of nationality has a treaty with the United States. Or, you know, a better solution will be Jeff's program, where you would enter into possibly an H1B solution and then kind of like wait it out to see what else we could do for you.
Of course, the question said that the foreign national has maxed out on H-1B
Oh, yes,
time.
they have
So
done that, correct.
they've done the total of
Mhm.
the total of 6 years. So I'm glad you asked that question because it's important for you to understand the cap exempt H-1B does not get you any additional time. You are still part of the same 6-year cap. So if you're maxed out, it's not going to be possible to get a cap exempt H-1B. However, I will say that we have been successful. When people say they're maxed out, you might not exactly be totally maxed out. If you have even a few days left, it might be possible to, well, it depends what I guess if your current status is H1, H4, you've already changed your status to H4. A couple of days in H1B won't help you. But if for those who might be about to max out, if you can find a little bit of time or just prior, if you can find even 1 day, it is possible to file an extension of your H-1B. I'm waiting to see what Marjan's going to say with this idea, but we do it quite frequently. If you have even 1 day left, we would file an extension for H-1B asking for 1 more day. And there is a rule that says if you timely file an extension of H-1B, even if you only have 1 day that you're asking for, you're entitled to work for up to 240 days while you're waiting for that decision to see if they're going to grant you the 1 day. And that is totally legal. And I don't find it unethical to follow the law by filing an H-1B extension for asking for 1 day. We would not file premium processing. It's taking maybe 10 months to make a decision, and you're legally working in H-1B for that extra time. So not for everybody, but it's a solution for some.
So yes, Jeff, you're referring to INA 245K, which is my favorite favorite go-to when in times of trouble. Yeah, so 245K allows for you to work a bit longer while you're waiting for your for the processing of your visa. In your situation, we may also want to look into possibility of maybe switching you over to an F1 if H1 doesn't work for you. We could maybe look into what program, maybe go into like a F1 a student visa mode for a little while you weigh your options possibly for EB5. So yeah, I mean, Jeff is absolutely correct. If you file for your change of status, which in some instances you can file online as well, as long as that application, you have a receipt number for it, then you should be considered in status until there's a decision made on your case.
Thank you, Marjan. Jeff, we touched on this previously, but can you quickly highlight what skill sets are actually necessary to apply for something like the Build Fellowship or another CAP exempt H-1B?
Well, you need to qualify for H-1B. Though that you need those skill sets. H-1B requires you to have at least the equivalent of a U.S. bachelor's degree in a specialized field. Examples: a bachelor's degree in computer science, that is a specialized field. Mechanical engineering, any of the sciences, and plenty of other occupations. A specialized field is where you need a certain degree to know how to do the job. Okay, here's an example of what's two examples of terrible H-1Bs. The first would be someone who's going to be teaching computer science, but their only degree they've ever had is in French literature. They just sort of learned how to do computer science on the side, and they've been tinkering for years, and now a university, maybe a community college, has asked them to come lead a seminar on computer science, and you need an H-1B. It's not going to work. You don't have a degree that is required for the job you're going to do. So that is not a good H-1B. And many people are surprised to hear another terrible H-1B is the job of Chief Executive Officer, because CEO does not require any particular specialized degree. There are people who are CEOs who have degrees in American history, dance, or even ethics, a degree in mechanical engineering. They come from all sorts of fields. And also, the job of CEO does not even require any degree, because Bill Gates never got any degree, and yet he was CEO of Microsoft. So the U.S. Immigration Service is not granting H-1Bs for the job of CEO. But the skill set you have to have is really that degree. At the Build Fellowship, we're requiring also 2 years of experience in that degree, because we're putting you to work teaching undergraduate students in that field. And we need to know you have at least 2 years of experience working in that field, not just the degree.
Thank you, Jeff. Marjan, a follow-up to one of the previous questions, and they ask, if I'm waiting for my H-4 approval, can I still continue to work?
I would be very careful about that. As we've pointed out, the 245K, Jeff, what do you think? With the 245K, I'm not sure if it will kick in for an H4. So I would be very careful, and I would just kind of like wait it out until you have an actual EAD card. especially if you file for an EB-5, as Jeff has pointed out, we are getting those in 2 to 3 months or so. So I would play it safe and wait until I have an actual EAD card in my hands before I start working again.
Believe that this section 245K, which is the savior for people who have been accused of working without authorization, is only good if you're getting the green card through EB1, EB2, or EB3. If you're getting the green card through EB5, I don't think 245K will help.
I think it does, Jeff, and yeah, it's up for debate, but I believe because it's EB-5 is still an employment-based category. I actually had to look it up a while ago. I think EB-5 may be able to help you for that, but I would advise whomever this individual is to have an individual consultation with Jeff or myself, and we're
Yeah.
happy to research that for you.
Yeah.
But I think 245K surprisingly does relate to EB-5.
Great.
Okay,
Um, I'm I'm looking at one of the questions, Trevor, if you don't mind. I think this is interesting. Someone is asking that they're doing a direct EB-5 project while being on
Yep.
H-1B. Would that work? If you don't mind, I'll answer that question. So if you're thinking of doing a direct EB-5, that's excellent. We may be able to actually look into filing a concurrent adjustment of status for you, depending on the geography of your business. So if your business falls into a TEA area, a rural or infrastructure geographical location, then you may very well not even need the H-1B to sponsor you, because we could file for your I-485 potentially, depending on the geography. So yes, the answer is yes to that. Or if you want to, again, play it safe, you can certainly stay on your current H-1B, because H-1B, as I mentioned previously, is a dual intent visa, so you're able to do both.
Yeah, thank you, Marshawn.
Of course.
Here's another question here that I can answer. They ask if I'm on an H-1B and I have an opportunity for EB-5. He wants to understand the difference between TEA and rural projects. So Marjan hinted on this earlier. If you are in the US, there really is very little difference between a TEA and a rural project, because with either one, you're investing 800,000, and with either one, you can file for that adjustment of status. So in that scenario, I would recommend that you select a project that is financially best suited to you and your preferences. I would not put a lot of emphasis on rural versus non-rural.
Yep.
Let's see. Here's another question. I think this is probably for Marjan. They ask, can H-4 family members go to school and work in the US too?
Absolutely, so long as you're under 21, because once you go, once you're 21 years or older, or if you get married, while being under 21, then you kind of fall out of that protection. So as long as you're under 21 and you still have valid I-94, you should be able to go to school.
All right, thank you.
Sure.
Another question here related to rural versus TEA. They ask, are all rural geographies TEA? And then what about urban locations? So yes, if you're in a rural area, at that point, we're not looking at the actual employment data. It's simply rural, and the rural nature of the location qualifies it as a TEA, and also for the priority processing for rural projects. So rural is rural, and TEA is related to, in urban settings, TEA is related to the actual employment data in that geography. But in either case, these projects are going to provide you that data, and you can also consult with various professionals in the industry to help you understand those nuances better. Let's see. I don't know if I see any other questions here. These slides will be available. This presentation will be available offline. If you guys have any questions related to EB-5 investment, immigration law, H-1B exempt programs, please don't hesitate to reach out. Jeff or Marjan, do you want to say any last words?
Well, guys, this is an exciting time to file for EB-5. This is how I see it. If you're here on an H-1B, as long as you keep yourself in status with a program like Jeff's or any other program, then this is the best time to file, especially if you're here, if you're an Indian or a Chinese national, working here on H1. I have a lot of my Indian nationals, especially with I-140 petitions that are approved, and they've just been waiting and waiting for 10, 15 years for that visa to become current. So this is the right time to file for EB-5 and look at great projects like Trevor's and some of other great projects that are out there. And this will allow you to actually file for your adjustment of status, and you could be looking at your combo card, which is, your EAD card, which allows you to also travel within 2 to 3 months. So I think this is a fantastic time to be filing for a EB-5. And I see a question about Iranian. It says, what about Iranians holding Canadian passport? EB-5 doesn't discriminate. So if you're an Iranian holding a Canadian passport, you have other options as well. You could do an E2 visa and then consider an EB-5 potentially, or you could enter on a TN and check out projects. And we're happy to guide you on that.
Thank you, Marjan.
Of course.
Jeff, do you have any final words?
Well, I'll just say, I think the theme of the program is, as Marjan and I were describing, if you are running out of work authorization in the US, or if you're outside the US and you are stuck in one of these terrible processing delays, you have some options to consider. And whether it's E2 L1 or a cap exempt H1B, Marjan and I are here to talk about it, or any immigration lawyer, but don't sit back and wait because there's information for you out there that could be really helpful.
Also, guys, this cap exemption and the visa availability is not going to last forever. Jeff, and Trevor, I think we're going to be okay through next year probably, but these set aside visas will run out eventually, and we're eventually going to look at retrogression. It may not be as bad as it was prior to RIA, but eventually we will run out of these cap exempt visas.
Yeah, thank you, Marjan. That's a great point. We looked at that bulletin earlier in the presentation, and there's lots of Cs at the moment. We're current in most categories here, but that's not going to last forever. It wasn't the case just a few years ago. So now is the time to invest. Now is the time to make a move. Generally speaking, things don't get better in the future, and now is the time. Take the opportunity. Take advantage of concurrent filing, cap exempt H-1B, L1, whatever option that suits you best. I encourage you to make a decision sooner than later.
And Trevor, one last thing, just I would leave people on this note, because basically a lot of my clients don't realize that you can make partial investment, whether it is your own individual EB-5 project or in a project like Trevor's. A lot of regional centers are sensitive to people's finances. And so if you have, let's say, half of the funds available, but the other half is being provided by sale of a property that is, pending, then most regional centers do entertain the partial investment, because under EB-5 laws, you either have to have been fully invested or be in the process of investing. So as long as you can show that you did have the funds on the day that we file for you, and that it's just a matter of time, or some countries like India, Iran, they have issues with the transfer of funds. So there are good circumstances under which we could file for you with a partial investment, and then do what we call an interfiling later on. Once all the monies are in, then we'll do a second filing called interfiling, where we would show U.S. immigration the full picture of your finances.
Great point. Thank you, Marjan. We appreciate everyone's participation, all the great questions. Marjan and Jeff, thank you for your expertise. And again, anyone please feel free to reach out to any of us for any additional questions related to this topic. We thank you guys.
Thank you.